Afternoon. Welcome to this session of the oral arguments for the Iowa Court of Appeals. I am Judge Mary Cicchelli, and it's my privilege to be presiding today with my colleagues, Judge Buller and Judge Langholz. Today, we will be hearing two cases. We will have a change of panel in between the two cases. The first case on our docket today is U.S. Nursing Corporation, DBA Fast Staff, Inc., and Safety National Casualty Corps versus Cynthia Decormier. Am I saying that right, counsel? All right, very good. U.S. Nursing Corps is the appellant and is represented by counsel Christopher Spencer. Ms. Decormier is the appellee and is represented by attorney Matthew Novak. Counsel, are you prepared to proceed at this time? Whenever you're ready.
Court. This case involves a proceeding on judicial review from a decision of the Iowa Workers' Compensation Commissioner. The primary dispute here is one in terms of figuring an average weekly wage and a rate for purposes of benefits under the Workers' Compensation Act. Some of the important facts that are kind of pertinent to the analysis: this particular injured worker was found to be intermittently full-time. Her situation is a bit different than you might experience for your normal employee who might be injured in a workers' compensation case. The claimant's worked as a traveling nurse since 2011 for this employer. She is free to take assignments as she sees fit. She's not forced to take any assignments. And she works full-time when she is on assignment, but her work involves large gaps between those assignments. So she will pick and choose, and she chooses to have gaps in time between her working. And the result of this is that her W-2s and her wages for the year of 2019 and 2020 show that her earnings are $56,718 in 2019 and $48,923 in 2020. This kind of leads into the dispute here in terms of what we need to do with somebody like her who works intermittently full-time rather than a normal full-time worker. The goal of 8536, which is the code section that deals with how we calculate average weekly wage. There are multiple sections in there dealing with various situations. But in this circumstance, this claimant does not fit neatly into any of those boxes.
Do you agree that she was paid on a daily or hourly basis?
When she was working, she was indeed paid on an hourly basis. I believe that is the record.
So why doesn't she neatly fit in paragraph 6? That's a case of an employee who is paid on a daily or hourly basis.
If one was to apply the code and the statute mechanically, she could fit into that section, and that is what the commissioner did. But I believe the Supreme Court has said that these statutes are designed to be applied flexibly and not in a mechanical fashion, with the goal being that we try to find something that fairly represents someone's customary earnings. That's the Hannigan case, and they did something similar in the Jacobson case we cite in our brief, where they looked at 8536.6 and throwing out uncustomary weeks to arrive at a customary average weekly wage, rather than just grabbing 13 weeks. The goal of this exercise is to try to get something that approximates someone's customary earnings. And in this particular circumstance, we believe that 8536.9 actually is a better approximation of that.
So let me ask you about that. Subsection 9 requires proof that the worker either earned no wages or earned less than what would be customary in her line of work. Do you agree with that?
That is what the Supreme Court has held, yes, Your Honor.
Statute says, right? Okay, where's your proof that either of those apply here?
We believe that that applies because she was found to be intermittently full-time, and we would cite to the Lopez case that came before this court previously, wherein the commissioner took someone who was working intermittently full-time, much as the injured worker here, and applied 8536.9 to arrive at that.
Evidence in this record that the worker either earned no wages or earned less than was customary.
We would rely upon the findings of the agency that said that she was intermittently full-time. Those are the same findings that resulted in that finding in Lopez and met that burden to establish that.
There is no evidence she earned less than the customary wage.
We believe that is just borne out in the record. A full-time nurse would be expected to earn wages for the entire year rather than working on an intermittent basis. She does not earn a lesser wage while she is working, but if you look at her in the aggregate over the course of the year, her earnings are substantially less than one would expect from a full-time nurse that worked full-time hours year-round. That is why she's under that section.
That.
It is in the testimony, it is in the record, Your Honor. I cannot provide a specific citation to the page in the record, but I believe it is in the testimony in the record about how she works, and in her wage records and in the assignment she accepted. She only works full-time for short periods of the year, and then it's off for part of the year.
Seems to me that you're jumping to like saying we should look at the whole year to conclude she's less than customary for the whole year. But I guess I'm not sure I get that out of the statute. I mean, it starts out in the unnumbered paragraph, like the assumption being we would just do the weekly earnings in the week that they were injured. Like that's where you start, as I understand it. And then if we do hourly or daily instead of weekly, that's 6, then we're going to, look at 13 weeks, and 9 is another exception to look at the current week. If your current week is lower, you're not fully employed, less than the customary rate, we're going to let you then jump. But why is my interpretation wrong that we shouldn't be like starting at, even for 9, just looking at the 1 week? And I think that week, there's no argument her wage was less or that she was underemployed or any of those things.
Those sections in 6 is designed to address a different circumstance, so you would have to meet some criteria for those. But the Supreme Court has said that our goal is to find a customary wage and has colored outside those lines for somebody who might not neatly fit in any of the boxes, like they did in Hannigan, where they came up with averaging 2 weeks of wages, which is not necessarily provided for in the code. The whole goal of this exercise is to get to something customary.
Well, isn't part of the goal, too, to sort of be doing swift justice and, having easily workable rules? And there's a lot of presumptions here, even, in the weeklies context. We just look at the 13 weeks if you hit into 6, and that might not be the most accurate for the whole year, but that's what the statute says to do. Why shouldn't sort of some of the simplicity factor into the analysis too?
The Jacobson transportation case dealing with subsection 6, you may not even take all of the 13 weeks that precede an injury, just blanket take them. You could end up excluding out certain weeks because they are not customary. So the whole goal of this is to arrive at something customary. And what makes this clear here is if we use the average weekly wage that the commissioner arrived at, if she earned that wage every week for a full 52-week calendar year, she would have to earn just shy of $150,000. That is 2 to 3 times what she's earned in any of those preceding years. That is why we believe this shows that this is kind of an absurd result here. This is not customarily reflecting what this particular worker earned in a year. And that's why we believe that it would be more appropriate to take the route that they did in Lopez and to use 9. She is intermittently full-time, and that would be the appropriate way to treat her, since she is not quite as good a fit for any of these other boxes to arrive at what is a customary reflection of her earnings by virtue of the way she just works over the course of a year. We believe that the commissioner and the district court has drawn the line of industry too small and saying, well, traveling nurses, they do this from time to time. She is a nurse, and she makes herself unavailable for work for a good part of the year. And so if you just take her under 6, you capture most of her earnings for what is for her an entire year in a short period of time, and we don't believe that meets with kind of the goal of what we're trying to do here, is to get something customarily reflecting her earnings. And if you do what we say, her average weekly wage and resultant rate is much lower. We've overpaid her benefits, and that kind of disposes of the rest of these issues here that are presented, because the second issue also deals with the imposition of penalty. In this circumstance, the commissioner imposed a penalty on a period of the benefits for the differential between the rate.
Was there an investigation that was done in that 8 months of time that had transpired?
The investigation, they provided the counsel the information about how the rate had been figured shortly after he inquired. The case was originally handled in Missouri, where the claimant here resides. And later on, they asked about Iowa benefits. And after that, there was some inquiry about the rate, and that's when they provided him information about, they took, I believe it was $52,000 and some change, divided by 36, and arrived at an average weekly wage, and a resultant rate of $966 and some change in Missouri, which is what was paid to her throughout the claim. If you use that same average weekly wage that they provided to opposing counsel, the rate in Iowa is actually slightly lower than what was being paid in Missouri. In Iowa, you take an average weekly wage, and there's a table that the commissioner uses by rule. You find your date of injury and plug in the information, and it gives you a rate. And in Iowa, that rate would have been lower. So they continued to pay her at the higher rate, even though arguably the lower rate would apply. Later on, additional arguments were made about her rate and it being lower. The arguments you're hearing here today about her rate, more specifically. And more information about that was put in place on September 1st, and I see I'm out of time.
You are out of time. You will have some additional time on rebuttal. Thank you, counsel. Mr. Novak.
May it please the court. This is a simple case. Cindy Decormier was injured. It was an admitted work injury. There's no dispute about causation, healing period, permanent partial disability, gross weekly wages, MMI. None of those issues that you typically will see in a work comp case are at issue. The only issues on appeal are the same issues that were presented to the deputy. It started at day one of my involvement, and that is, what's the proper wage rate? And subsequently, what's the entitlement to penalty benefits? There is substantial evidence to support the district court's conclusions and findings. There is no dispute that Cindy worked as a nurse, traveling nurse, since 2011 and since 2019 for this particular company. The representative for FASTF testified that she is a full-time employee, and it's not unusual for their employees to take a week or two or three off in between assignments. She was a full-time travel nurse.
Opponent's argument that has at least some facial appeal is that under the calculation used here, your client's getting money as if it was maybe 2 or 3 times what she had made on her W-2s the couple of years leading up to this. I would invite you to tell me why I shouldn't be concerned that that is, at least at a facial level, what it looks like.
Well, at a facial level, first of all, she's under a written contract making $65 an hour. A week before she's injured, they voluntarily increase her pay by $10 an hour. Her next assignment pays $99 an hour, then $115 an hour. The time period that she's off work after being hurt is more reflective of what she could have earned during that time period. Facially, the same type of argument. The code doesn't go back and say we should look at the W-2 for the prior year. The code sections, frankly, are subsection 6 and subsection 7. Either one of those could have been applied in this case. What they did is, and argued from the beginning, is if you look at the 10 weeks that she's under contract and say, well, she didn't work 13, what would she have earned had she worked 13 weeks? Well, she's got a contract. That would be subsection 7. Subsection 6 just says, well, she's a full-time employee, so let's ignore those 3 weeks that she was off and go back and pick up her last 3 weeks, which is what the deputy did. What the commissioner did and what the district court found was a proper analysis. So I hope that answers your question. But there's nothing in the code that says, oh, gee, every case we'll look back and see what they earned 6 months ago or 4 months ago, especially when it's the same employer. Keep in mind, as a travel nurse, and the record reflects this, the more she is paid, the more FASTF is paid. They're not paid according to what she earned in the past. They're getting paid whatever her current rate is under their contract, and that's in the record as well. We wouldn't be here if she had got hurt on 13 weeks and 1 day. We wouldn't be here. There wouldn't be an issue. And that's why the deputy was faced with just the simple fact, is it subsection 6 or subsection 7? And that's why we're here. Frankly, I think substantial evidence could support a finding either way. But we're here to uphold the district court's decision because there is substantial evidence. One of the things that I want to point out is, even in appellant's brief, they admit that there is a preliminary finding that's required to show that she would have earned less than the average worker for subsection 9 to apply. And if you look at the Swiss Colony versus Dupemeyer case that's cited on page 18 of appellant's brief, when they concede that point, when you look at that case, they make the same point that Judge Buller was making, and that is there's nothing in the record other than argument to say, well, less than 40 hours, that means you're part-time, means you're subsection 9. They said, no, you have to have specific evidence. In this case, there is no evidence. The commissioner found no evidence. The district court found no evidence to support the application of subsection 9. I do want to point out as well that when we talk about penalty benefits, keep in mind that there is substantial evidence to support the commissioner's factual findings. It's a different standard review, I believe, on the penalty. It's just if there's substantial evidence. And the amount of penalty that was awarded was very moderate, and that's also discretionary with the commissioner. I want to point out that even though the commissioner said, well, as of September 1 of 2021, counsel provided at least a minimal explanation. A year later, in response to requests for admissions, they were asked, how did you calculate the rate? And they said it was according to Missouri. That was the explanation in litigation. From the day one until the hearing, Missouri calculations were the only basis for penalty benefits. But we're here to support the commissioner's findings. There was substantial evidence of an unreasonable delay, and the amount I don't believe should be in interest or in dispute. I did want to point out as well that in their brief, they raised some type of mathematical error that the commissioner made. There's no record of that ever made prior to their appeal brief, and it, I don't believe, has any bearing on any of the issues because the amount of the penalty award is discretionary with the commissioner.
No. Was that issue litigated at any point in this case?
Which issue? The
In the math problem.
have all been undisputed all the way through. It was just a mathematical error that they have asserted in the commissioner's findings. But there's been no dispute from day one as to the amount of wages or anything of that nature because it's the same employer. If there's no further questions, I'll yield the rest of my time.
All right. Very good. Thank you, counsel. All right. Any rebuttal?
We believe that the rate issue, there is findings in this record that support the finding that she would fall under subsection 9 in terms of her being intermittently full-time. That presupposes she's not the same as a full-time regular worker. Those are the same findings from Lopez that supported the agency's finding that somebody like in Lopez was under this code section.
Witness testified that her earnings were, and this is a quote, typical, customary, or usual for a traveling nurse?
Well, it depends on how narrowly we're trying to draw the box around the line or industry. We say she should be found to be a nurse. She is working as a nurse.
My question was, your witness testified to that, right?
Testified about it was not unusual for nurses to have breaks in their record, if I recall correctly. Yes, Your Honor.
Your witness testified the earnings were typical, customary, or usual. Do you dispute that?
I do not recall exactly what the witness said verbatim, but I do remember there was testimony from a representative about the nurse and that there was, it wasn't unusual for them to have breaks in their assignments, such as were present here. But we believe if you apply these statutes in a flexible manner, as the Supreme Court has directed, with the goal being trying to find someone's customary earnings, that's why we would look at this in the aggregate. This is an unusual case because of the way she earns and the way she works to try to figure out something that more closely approximates what she actually earns. And that's why we believe that those findings are present in the record. We're not just talking about a substantial evidence question. There are some findings in the record that would support the application and support doing this in this fashion. And we'd have to look at the statutes and interpreting the statutes and what they mean. In terms of the penalty benefits issue, the calculation, the first time the claimant was actually awarded a penalty was by the commissioner. That didn't happen at the deputy level. And so the issue was addressed when the issue became apparent, because the agency had then ordered a penalty at that point. At the deputy level, which is a proposed agency decision, there was no penalty awarded. The issue was argued on appeal to the commissioner, and the commissioner is the one who included the imposition of the penalty.
Commissioner to correct that error?
I do not believe there was a motion for rehearing filed. No, Your Honor.
That error preserved.
We believe that the issue was presented to the agency in terms of the penalty, and this is kind of incidental to that. And we believe it would be properly addressed at this level. We also...
Preservation requires that the issue be litigated in the sense that the court or the agency is alerted to the error and asked to correct it. Did you ask for that to happen?
I do not believe there was a specific motion filed after the agency's decision, the commissioner's decision. No, Your Honor. In terms of the actual imposition of the penalty itself, those are issues, factual issues go into it, but they can be determined as a matter of law. It does not matter whether we are determined to be right about the issue. Clearly, there's a reasonable basis based upon all of the arguments that have been arrived at. The agency doesn't seem to dispute that there's a reasonable basis to fight about the rate here. And the claimant was provided an explanation, enough to alert them as to the issue. We believe that's all that the code would actually require in terms of alerting them to these issues, the communications that are required by 10A 315. And that is all that is necessary to provide them an explanation enough that they can be alerted to the issue. And so we believe there's no basis to impose a penalty here based upon the record. Thank you, Your Honor.
Counsel. And thank you both for your briefing and arguments today. We will take this matter and consider it as submitted. We will get a ruling out as soon as we are able. There is one more case on our docket this afternoon, but we will change panels and then we will be ready for that.